My name is Amanda Marzullo, and I'm with the Texas Defender Service, and I'm here to testify in support of both House Bill 147 and House Bill 316. I think that one thing that I want to clarify about the committee substitutes is that they only apply to one provision of the law of parties. So there are two ways that you can be held accountable under Texas law for the conduct of another. The first is under 702A, when you intentionally participate or assist someone in committing an offense, such as directing them or ordering them, sort of like Justin mentioned in his example, to commit and carry out an offense. That provision is left alone and unaffected by that. So prosecutors are still going to be able to seek the death penalty when someone intends to participate in a murder. What it takes death off the table for is under 702B. And that's where you conspire to commit one felony and there is an act in furtherance of the felony. So that's when, for example, like in the Wood case, a group of people conspire to commit a robbery and a murder is perpetrated by a co-defendant in furtherance of the robbery. Under our laws, you're actually on the hook for that capital murder, even though you didn't intend to assist and didn't enter any sort of agreement to engage in a murder. And I really believe that this bill is necessary to preserve the integrity of the Texas death penalty for that reason, is that it does open up the possibility for someone who is, I guess, technically liable for a murder under Texas law, but didn't intend it. Let
me ask you a hypothetical.
Okay.
So a group of people conspire to engage in a gang rape, but one of them pulls the trigger or slits the person's throat, and that was not part of the conspiracy. That would also fit under the situation that you just described. This is the part that this brings the complexity to my mind, because they conspire to commit the one felony, and someone decides to go one step further. They think, you know what, we can't leave her alive because she's going to turn us in. And so I
mean, it's a terrible scenario, but I'd also say that we need to draw the line somewhere. And because the person who did pull the trigger...
So we want those people on the hook for the death of that woman in that scenario?
Well, they're still going to be liable for capital murder, sorry. They're still going to be able to serve life without parole. They will never see the light of day again. They will not be out in the public. They will still serve for the offense. But the problem with our system right now is that we have people who commit acts of multiple murder who receive life sentences on a regular basis. That happens all the time. In fact, it happens more often than it doesn't. And then you have individuals who didn't intend and didn't perpetrate murders being sentenced to death. That creates a proportionality challenge to the death penalty in our state. And I understand that no system is going to be perfect, but I really do think that we have to draw it somewhere. And I think drawing it along the top line of intent makes a lot of sense for public policy purposes.
I appreciate your testimony.
Thank you.
Do you have any questions for Ms. Marzullo? And I stepped on your last bit of time, I'm sorry. Did you have some more to add?
I mean, mostly I think I hit my major points. Yeah.